big story of the day, of course, is the Derek Chauvin case. We're on day 3. We're still in the middle of jury selection, and we've actually got about, I would say, a third of the jury pick. We got 5 people on there. There's a little bit of question about whether we're going to have 14, maybe 15, maybe 16 jurors. And so we're getting close. We're actually filling this up more quickly than I thought we would. And so that's good news. Now, in the middle of the jury selection that was taking place today, the Supreme Court from Minnesota came out and said, well, we're not going to be accepting Derek Chauvin's appeal. Remember what happened here? Let me frame this out a little bit. Derek Chauvin originally was charged with 3 different violations. There was a third-degree murder charge that was dismissed by the lower-level district court judge early on in the case. Just said, well, there's no probable cause for that. The reason why this was even in question is because if you read the statute itself says that in order for somebody to be guilty of that offense, they had to have been causing harm to others with an S. Plural. And here in this case, it was just Chauvin and Floyd. There were no others. It was just Floyd. It was just one person. And so what the lower level judge, Peter Cahill, said that there's no probable cause for this. Well, the government appealed that, and they said, yeah, there is, because others doesn't mean multiple people. It just means one person. So they appealed it to the Court of Appeals. Court of Appeals said, yeah, in fact, you can. It doesn't have to be multiple people. So they came back down. But in the middle of that, Derek Chauvin said, well, I don't like that Court of Appeals ruling. And so he took it up to the Supreme Court. And that's why on Monday, we had all of these different questions about whether this trial was going to continue to move forward. Because theoretically, since that issue was being appealed, you can make an argument that the lower level trial court doesn't have jurisdiction over the case anymore. And in fact, the prosecutor's office was saying the same thing. In other words, they needed to wait until the Supreme Court had made a decision before they could pick back up. And the judge said, no, we're not going to do that unless they tell us to stop moving forward on this case, full steam ahead. And they've been doing that. Today, though, we did get a ruling from the Supreme Court. Derek Chauvin was appealing to them, and they said, no, it's denied. We're not going to look at it again. The Court of Appeals ruling stands. So let me show you what that looks like. This article came over, again, from startribune.com. They're doing great stuff, and we're going with them as our primary source because they're local to Minnesota. Jury selection was well into the second day today when the state's high court said, without elaboration, I'm going to show you the order here, that it would not hear Chauvin's argument to overturn the appeals court ruling that said a third-degree murder charge against him was improperly dismissed. In other words, it can come back. The judge in court today, Peter Cahill, announced the development Wednesday afternoon, said he would address the matter Thursday morning, so that's going to be tomorrow, when proceedings move towards seating 12 jurors and 2 alternates. So we're looking like 14 total. Prosecutors had argued Monday that the entire trial should be suspended since Chauvin's attorney, Eric Nelson, asked the Supreme Court to intervene. The Attorney General, Keith Ellison, also called the Court of Appeals, filed a motion also asking to postpone the trial until there was a resolution, but no guidance was given, and selection just started. And I think that's to this judge's credit, right? Unless somebody tells him he cannot move forward on this case, Judge Cahill is just grinding this thing ahead, which is a way to handle it. And I actually sort of applaud the tenacity. You know, the whole city's on lockdown or barricaded up, and they've got a lot of provisions out there to ensure that this is a fair trial. They've got a bunch of jurors who've already been questioned and called in. And so this judge is just not letting up. And I think that is to his credit. I actually like that immensely, that he's just driving this thing home. Here is the order from the Supreme Court. We can see here, very, very simple, one-page document filed today, March 10th, in the Office of the Appellate Courts. The state of Minnesota Supreme Court, Minnesota versus Chauvin, says hereby order that all of these people for the government can be admitted as pro hoc vice. So you see here, we talked about some of these people, Matthew Frank, of course, Neil Kumar Kadyal, Nathaniel Zelinsky. They're all going to be pro hoc vice, which means they're not from Minnesota, but they're going to come into Minnesota, and they're going to help the government with their cases. It also says, as a part of this order, it is further ordered that the petition of Derek Michael Chauvin for further review and the same is denied. That's it. Signed off on by the Chief Justice, Lori S. Gildea. So we don't really know what the judge is going to do with this. We do know that the Supreme Court is not going to be hearing Chauvin's appeal. Chauvin obviously does not want an additional charge to be brought out back against him. The Court of Appeals here said that, yeah, the trial court needs to, if the government can sort of re-urge that motion and reestablish probable cause, then they have to follow the Court of Appeals interpretation of that statute. So if the government wants to bring this charge back and says there's enough probable cause to do it, and they believe they can integrate it into their case, the judge sort of has to maneuver around that. And there's going to be some logistical questions that are probably going to pop up tomorrow. I don't know what Eric Nelson's response here is going to be. I don't know. I mean, I think he could easily make the claim that he's not prepared to move forward on that charge. He was only prepared on the first 2 charges because the other third-degree murder charge was dismissed some time ago. And he could say, no, I mean, I haven't prepared any evidence, any exhibits. I haven't done any interviews for those people. This is a new charge, essentially. And that could really throw a wrench into things. Now, that being said, it sounds like jury selection might actually be done this week. So we have a total of 5. We had 3 that were put on the bench or on the panel yesterday, another 2 that came on today. So if we can get, if they hustle tomorrow, because there were some additional motions that were discussed earlier in the day about training. There was another witness that the government is going to call who is a martial arts person. And he was saying that there is likelihood that he's going to testify about his martial arts skill set and whether or not he would have performed sort of the same maneuver that Chauvin performed on Floyd, whether he would have let off that person, whether he would have done something differently given his experience. As you know, in martial arts, you often use chokes, right, in order to subdue your opponent, especially in Brazilian Jiu-Jitsu and some of the other Jiu-Jitsus. So it's pertinent, it's relevant. They had a lot of discussion about it, and the judge sort of split down the middle on that question. Yeah, he can testify it, but he can't conclude that it was the cause of death, loosely around those lines. So a lot of that was dealt with this morning, which means that it took some time out of the day to pick the jury. Now that some of those questions are out of the way, presumably, well, there's probably going to be more of them tomorrow, but if they can get back on track, if they can really just start grinding through these jurors, we may get close to being done this week. We'll see. Probably not. Probably go into next week. But my point by going down that digression is there is still time. The trial is not set to start until the end of this month. And so the judge might say, well, yeah, we're adding that third-degree murder charge back. You've got about 2 weeks to figure it out. Go get it done. And so I'm not real familiar with the rules of procedure are in Minnesota. Just generally speaking, I don't know whether or not, they have some pretty strict deadlines about bringing charges back or what have you. But the judge is going to tell us tomorrow what he intends to do about it. So interesting news. We may see a third charge come in, which I was expecting anyways. If you go back on the first video that we did defending Derek Chauvin, I went through all 3 of the charges because I suspected that it would be coming back. And here it is. So now he's going to be facing 3. We prepared defenses from my perspective on all 3, and we're going to measure the performance that we see in this trial as it moves forward against sort of my hypothetical predictions. All right, so let's take a look at the layout now. This is back to our court diagram. We can see here a lot of the same parties that we had yesterday, but we do have 5 jurors who are now in our jury panel, and I want to go through them. We're going to go through them. I'm going to show you a couple corrections that we have. So this is what the panel looks like. We know it's now going to be 14 people. We've got 1 through 5 who have been seated. 4 and 5 were seated today. 1, 2, and 3 were seated yesterday. And so we'll see how far we get tomorrow. Maybe we'll get 6, maybe we'll get 7, 8, maybe 9. And then on Friday, maybe we get another 5 if they hustle. So we could get the whole panel seated this week if they hustle. What does the jury box look like? Or what does the courtroom look like? I thought this was interesting. Great graphic over here from Mark Boswell over at the Star Tribune. He put this together. And I wanted to show you what the layout looks like because I think it's interesting. This is a little bit different than what you would traditionally see in a normal courtroom. And you can see how they modified this stuff. So first and foremost, they have the jurors all really separated. And if you look, you can see this is what it looks like. I think this came from within the courtroom where they have something very similar to this. But each juror gets a nice, comfortable chair, which is not normal in courtrooms. Normally they're sitting on, stuff that is okay, but it's sort of bolted into the ground. Then they typically don't get a desk. They're sort of writing on their knee. So this is a nice little setup. These jurors are going to be pretty comfortable. And they're also not sitting on top of one another, which is a very good thing as well. Typically, you'll see jury panels where they're just sort of just slammed in together, and that doesn't work if you are in the middle of COVID. So they did some really nice spacing here, and they also have, it looks like, so let me break this down, what a courtroom normally looks like. So I think what they did is they just modified this. None of this stuff up here where the judge is sitting, none of that really moves around. You've got the judge, you've got the witness stand. This, I think, is all built into the courtroom building. And so the witness will walk up this direction and sit behind these glass panels. And so you've got these really thick plexiglass panels that the jury is going to kind of have to look through in order to see their reactions. That's a huge part of a case, is the jury seeing your witness and seeing who's testifying. And so they're going to be looking through a couple big, thick plexiglass panels for some stupid reason, but that's all right. So they're going to do that just so they can play the COVID facade spectacle looking thing. That's fine. They're all following the rules. Happy that the trial is moving on, but is all of this necessary? Probably not, because they're sitting in a building in close proximity. As long as they're healthy and they're testing negative for the virus, I think it's a little bit overkill, but that is what it is. So ordinarily, none of the plexiglass would be here. And I think that I'm not familiar with this courtroom specifically, but traditionally in courtrooms, at least here in Arizona and some of the ones that I've been in around the country, this jury panel would really be condensed into an area like this. So you'd cram everybody into a little box like this, and then you would have pews or rows sort of in the back that the public can sit in. Then you have the bar, which is, anybody who's a lawyer goes in front of the bar, right? You sort of in that Jay-Z song, I pass the bar, and that's sort of where that comes from, is passing the bar. So you can go in front and be a part of the court proceedings. At least that's one interpretation of where that came from. And then the public will sit back here and they'll spectate. Well, of course, the public is not going to be available now. Only very limited observers are going to be able to be present in court. So George Floyd and his family, they get one seat. We have Derek Chauvin and his family, they get one seat for the observers. Then we have other pool reporters. We have a technician, very limited for public accessibility into the courtroom. And so traditionally, you would have a podium right there in the middle, and the prosecutor's seat would be over here, and the defense seat would be over here. As I mentioned earlier on this week, Derek Chauvin would really be sitting kind of back over here in the corner, far away from the jury, so that none of his squirming or fidgeting or any facial expressions that he makes are directly visible to the jury, versus if he's sitting right here, then they would be able to see literally everything. So now it looks like he is sitting over here, and his attorney, Mr. Nelson, is sitting over here, and the government's attorneys are sitting back more towards the back of the room, this looks like. So the attorney podium is here, defense and state seating, I believe the state is back here, sort of tucked away in this corner, and so they're going to be able to observe the jury. Eric Nelson's going to be able to observe the jury. We've got a podium here. We've got the court reporter sitting here. And they've just modified the courtroom so that there's more spacing here. They've eliminated the pews. They've sort of rotated the both parties around the courtroom, and it's interesting how they're doing it. Maybe that's too technical and geeky for anybody else out there, but it's interesting from a legal perspective on how they are doing jury trials. Still, jury trials are not happening in many parts of the country. Even here in Arizona, some courts maybe are doing it. We're doing bench trials. We're doing things over Zoom a lot of the time. A lot of court proceedings are over Zoom, but to actually have a full jury and a full courtroom, it's interesting. And so that's how they're going to organize it. We'll see how that goes. Now, let's take a quick look at a summation. So this is a jury table. This is a summation of the different jurors. And you're going to see here, like yesterday, we have emojis to represent the different people. We don't know their names. They're all, of course, under seal. Nobody can know their identities so that they're not being inappropriately influenced. And what we'll see is juror number 1 from yesterday, number 1, 2, and 3. We know that jurors number 1 is a white person. Number 2 is a person of color who's female, unknown, law enforcement, uncle, and she is a BLM supporter according. So these are just my notes that I made. Number 3, we learned that today is a white man. Yesterday, we weren't sure what he was. We just knew that he was an auditor. But today, we were able to glean that he is, in fact, a white individual, because when we learned that number 4 juror was also going to be white, there were some comments about that in the media. So number 4 today is a sales data person, and he acknowledged that George Floyd was under the influence and somewhat unruly. So we're going to break that down a little bit further. And then number 5 is an African-American man. A black man got seated. He's an IT manager, and he's an immigrant. He speaks multiple languages, and he acknowledges that he had a negative view of Chauvin. So we've got, it looks like 3 white males, 1 person of color female, and that's according to their characterization of her. And then we have 1 black male. So it's currently 4 males, 1 female, and we have 3 white individuals and 2 people of color. So, you can draw your conclusions off of that. And let's go through and see some more details. As we recall, number 1, we already talked about him yesterday. Number 2, not much more to report back on her. Number 3, as I mentioned, we said that this person yesterday, we didn't know what race he was. And so now today, this new box was added over on Star Tribune, or I clipped it from there. It says the newest member brings the number of white men on the jury to 3. So the newest member being number 4, which means we conclude that number 3 is one of the other white men. And there was another woman of color there for a trial, and it promises to take substantial amount of time addressing race in the context of a white police officer, detention of a black suspect who died later in that evening. And so we all knew this, that race was going to be, of course, right, an undertone throughout the entirety of this trial. And so, many people are just going to be analyzing the jury just on the basis of race. And in fact, some people might say that the entire decision on this entire case was all about race. It had nothing to do with anything that was presented in the court of law, which I think is not fair. I don't think that's a reasonable perspective on this thing, but you will see people who say that, well, there just wasn't enough black people on there, or there were too many white people, or there weren't enough white people, or what you're going to hear that all throughout the I think remainder of the trial. I don't think it's a fair criticism. We'll see. Everything I've heard thus far, I got to be honest, I think this judge is doing a very nice job of playing evenly to both sides. So number 4, this is the newest member today. First member who got added on. This is another white male. The newest member brings the number of white men on the jury to 3, along with a woman of color, for a trial that promises, as we read. Wednesday's first selected juror said he was not worried about being on the jury during a pandemic or troubled by security in place around the Hennepin County government, but how a trial is poised to eat up most of April that might impact the timing of his wedding set for May 1 in Florida. So he said, if I'm a part of this jury, then I will not be getting married on that date. He said before drawing chuckles, he said, that is me answering, not my fiance. Sure enough, the man was added to the jury, with Judge Peter Cahill offering him with a presumed masked smile, said, go ahead and throw me under the bus with your fiance. So a little fun in court. And we learned a little bit more about this guy. Native of central Minnesota. He is white. Again, everybody's going to be noting this stuff, so just get used to it. Works in sales data, is a father, enjoys sports and music. He saw the video of Floyd's death, reacted negatively. He answered on his questionnaire that he understood that Floyd was, quote, under the influence and somewhat unruly. So that looks like that might be a good fact for the defense, because I think they're going to be trying to show that it's all about drugs, the ingestion of drugs, fentanyl in the blood, and methamphetamine remnants in the blood, and other medical issues are all probably going to come into play, and this juror is already thinking that way. When pressed by Chauvin's attorney, Eric Nelson, on why he believed that, the juror said, quote, I'm assuming when someone is in handcuffs, they're in handcuffs for a reason, right? And so kind of is making a little bit of a presumption there, which, as a defense attorney, ordinarily you're not comfortable with that. But in this case, the defendant is a cop. So it's actually good for them. So this kind of reverses that. Ordinarily, if somebody is, let's say you have an individual who is charged with shoplifting, and they're being charged with a crime, and they're in the middle of a trial. And a juror comes up and says, well, if they were in handcuffs, they probably did something wrong. Probably a reason for that. As a defendant, you would say, wait a minute, that's totally inappropriate. What about the presumption of innocence? That's not accurate at all. Just because somebody's in handcuffs means they're detained. Doesn't mean they did anything wrong. They haven't been convicted or pled guilty to anything yet. And so that would be a little bit much. But this guy got on the panel. He also said he believes, quote, a police officer is more trained to assess the situation and share it in a court format versus a civilian who might be more emotion-based. I would have another big problem with this if my client were not a police officer, right? To say that in the middle of a court proceeding that a police officer who's a witness is more trained to assess the situation and share it in a court format. Actually, that's not bad. That's not a bad statement. I think I would have less of a problem with that now that I read it again. What I was trying to say is oftentimes what happens in court is you'll have an individual who comes in and says, all right, let's say that the defendant says, I didn't do it, or I didn't see that, or that didn't happen. I didn't say that, whatever it is. And the cop says he did do that. How do you weigh both of those witnesses? Which one's more credible? Well, most people will say the officer is. Because he's a cop. He's in a uniform. He's got a badge. He's got all these training and everything like that. But if it's just about an observation, whether somebody saw something or didn't, they should have the same amount of credibility. And the judge will oftentimes go through and educate people about that. So, no, he's just a witness. You shouldn't give him any more credibility just because he's a police officer. He can make mistakes. He can see things wrong all the time. As a jury, you got to weigh the witnesses evenly. And you got to give him the same amount of credibility. The cop is just a witness, just like other witnesses. And many people don't necessarily know that because it's a cop. So I think he's a little bit off on that, but not in a way that would make this juror struck for cause. I think that this juror can stay on that statement. He says here, however, he marked down the justice system for making, quote, arrests for a small offense like marijuana that are highly skewed toward black Americans. I wish our country and world would get better at that. I do have belief that people are treated differently because the color of their skin. Okay, so now we've got some statements that the prosecutor is probably going to be very happy with, which is very likely why this guy got on the panel. The defense attorney likes some of what he said. The prosecutor likes some of what he said. He continues, he says, when you look back at the phrase Black Lives Matter, yes, they do matter, and I don't see why anyone would be against that movement, he added, saying that he finds the co-opted phrase Blue Lives Matter in support of police short-sighted, although he does support law enforcement. So you've got some people here on both sides, the prosecutor, the defense attorney. They're hearing things that they like. They're hearing some things that they don't like. And so they're both going to sort of roll the dice on this juror, and he is on the panel. So that's number 4. A couple people got booted off today. They were in court, and the judge said, no, we're not going to let you on the jury. This woman was a white woman. She has lived in Minneapolis for 40 years. She said that she has seen portions of the arrest video, and it left her wanting to know more. She said, quote, there's undoubtedly more information that I don't have, said the marketing professional who grew up in Western Minnesota. Quote, so I am not in a position to judge. There has to be a more of what's going on here. Usually there are a series of events that happen. I would need to know more to have a firm opinion. Question on her opinion of the BLM movement. She said, Black Lives Matter, Blue Lives Matter, all lives matter is the beginning and the end of it. What happened? Well, the prosecution struck the woman from consideration ahead of questioning probably because of that statement. Right? That one statement alone where she says all lives matter, I think that's enough there for them to say, all right, that's not a juror that we want on the panel. So the prosecution said, you're out of here. Good move for the prosecution, right? Obviously, they want people who are more, I would say, sensitive to the BLM arguments and more in alignment with that ideology. If they could fill the jury panel up full of BLM people, they would do that, right? And they would win handily. And so they're trying to move that direction. The defense is trying to move the other direction. This woman said that. She's not on the jury. We have another individual. We don't know. We don't have a good emoji for him, but we have the day's third prospective juror, father of 3 girls, said he wanted to be on the jury not only to help deliver justice, but possibly see how public policy might prevent the same result in a similar incident. So I wanted to show you this. This paragraph is basically the same as the bottom paragraph, but they added in who is of Asian descent. So see, we're getting more and more racial identifiers as the story develops. So it said the day's third prospective juror, father of 3 girls. Now it says the day's third prospective juror, who is of Asian descent and a father of 3 girls, said he wanted to be on the jury to help. When Eric Nelson pressed him on that motivation, the man said, quote, the case is the case. As I see it now, policy is not decided here. Policy is decided somewhere else. My duty is only about this case. And as soon as that happened, the defense attorney struck him from a possible seat on the jury. And, I don't really know why the defense attorney did that, but he certainly didn't want him on there, and he will not be. The last juror of the day who is being seated is this gentleman. 5th juror cleared to serve is a black man who immigrated to the United States 14 years ago for school in Nebraska, moved to Minnesota in 2012. He said during questioning that he feels it's his civic duty to be on the jury. He promised that, quote, I will follow the law despite forming a negative view of Chauvin based on seeing part of the viral video of Floyd's arrest, while relating to Floyd's death and saying to the defense attorney that, quote, it could be anybody. It could have been you. The multilingual IT manager also said, I believe that I will be impartial. And so no objections, it sounds like. And we have a 5th juror on the panel. And so this is what it looks like. We are going to be filling up the rest of the seats here shortly, and we'll see what that looks like. It's going to be a busy couple of days. This might spill over into Monday, Tuesday next week. But we'll see. We'll continue to follow along. So please subscribe and join us as this trial continues to unfold. So let's take a look at some questions over from locals.com. You can get there. If you want to ask a question, go to watchingthewatchers.locals.com, sign up and support the show and ask a question. Our first one today comes from News Now Wyoming. Says, if you were the attorney, would you have filed a change of venue? Yes, I would have. I think that they did, and it got denied. I could be mistaken on that. A police station less than 2 miles from the courthouse was burned in the aftermath of the case. Why do you think they didn't? Part 1. Part 2, could it be possible appeal issue for bad lawyer decisions, to not request an obvious change of venue. I feel like I could be off on this. I feel like they did ask for that, or there was something that was done early on in the case and it just wasn't allowed. But I agree. I think this is a very important question here, right? To hold it right in the middle of the epicenter of where this all happened is concerning. And we've actually seen this come up from some of the jurors who were being questioned. I think today there was a juror that I didn't include in my notes here that said something along the lines of, yeah, I mean, I'm concerned about my physical safety and well-being, because what happens if Derek Chauvin's acquitted? What happens if he's partially acquitted? What happens if he's only convicted on this third-degree murder charge and not on the two more serious charges? So he's he's 2-1. Not guilty on 2, guilty on 1. What happens? In the middle of that, it's not going to be good. So, now you have to start thinking about this from that perspective as well. What are the jurors going to do, regardless of any evidence that's presented? What are they going to do? What kind of decision are they going to make just to ensure that they have personal safety moving forward? Just to ensure that a year from now, once everybody's identity in this trial is known, once everybody's been doxxed, once all of the information is out there in the public, are they going to have to live looking over their shoulder for the rest of their lives? And that is a real thing. People are really concerned about that. They were talking about it during a jury selection today, and I think the judge even relieved somebody for that very reason. Said, "Yeah, you're right. If it's too stressful for you, we can't have you here." Because it might cause people to vote one particular way just for the sole reason of ensuring their personal safety. The people who are getting on this jury are taking on a big burden. They're going to have to carry that around for a long time. And that is a pressure that the court has to consider. So News Now, Wyoming, I'd have to take a deeper look onto the motion for a change of venue. I felt like I read that, but it has been so long. I think it was something that I read back when these charges were originally filed against the officers. And I just can't recall off the top of my head why that didn't happen. But legal malpractice is kind of a tall order. Derek Chauvin may not have wanted to change it, to have changed the venue. That may have been the discussion that they had, where they would just wait out the pros and cons of it. And he said, no, I want to be here, right? I want to be right here where people know me. There's a jury of my peers, whatever. There's many reasons why you don't change venue, but it is concerning, certainly for the jurors. Now, I think the court's doing a good job. There are barricades everywhere. There's National Guard troops there. I think the last article that I talked about said that they were going to be pulling in officers from 11 different jurisdictions throughout the state to come in and beef up security. But it is a concern. I think it's a very important part of this entire proceeding, which is why the judge is moving this thing forward, because they don't want to go through this all again. Liberty or Death says the DOJ was heavily politicized under Obama Biden. Now that Creepy Joe is president in public, it isn't going to be any different, even more politicized even. He wrote the crime bill and Kamala prosecuted many under it before working her way up in politics. Who do you think they will come after next? Well, I don't know. I think that there's a lot on the agenda there. I think that anybody, of course, who is connected to the Capitol Hill, they're going to be under the microscope for a long time. They're not getting off easy. We're going to talk about in the next segment, or one of the upcoming segments, about the QAnon shaman and how I would say unfair or inappropriate the judge's ruling is in his case. So certainly that's going to happen. I think that they're going to be coming for guns. We're seeing a lot of the racial equity talk. Anybody who is oppositional to that. John Brennan said even libertarians are dangerous. So we'll see where that goes. We have Jeremy Matrita says, I would love to see more about your diagrams of the people in the trial. Those visuals are super helpful for us armchair trial watchers. More about your diagrams of the people in the trial. Those visuals are super helpful. Yeah, so I didn't draw that one, actually. So the one came over from the Star Tribune of the diagram of the courtroom. But yeah, I'm happy to continue to. So we're going to keep playing around with the emojis and the charts. Attorneys use a lot of these things in their trial preparation. We make charts. We have jury seating diagrams. As I mentioned on the show, there are even iPad pieces of software that you can use and sort of, keep tabs on your jurors and what's going on in a trial. So I will try to incorporate as much as I can into the show and kind of show you how this would be structured if I was, maybe second chairing or a part of the trial. We have Liberty or Death says, what is the likelihood that if the judge allows the third-degree murder charge and Nelson is not successful in a continuance, once the jury renders their verdict, can the judge issue a directed verdict? So that's a complicated question there, Liberty or Death. Let me read that again. What is the likelihood that if a judge allows a third-degree murder charge and Nelson is not successful in a continuance, once the jury renders their verdict, can the judge issue a directed verdict? So in Minnesota, I don't know the language that they use, whether it's a directed verdict or whether they call it something different. In Arizona, we typically refer to it by the rules. And what Liberty or Death is asking about, and the reason why it's complicated is because I think it's premature to be asking the question because we haven't seen any evidence presented yet. So essentially what he's asking, when you're in the middle of a trial, I'm trying to organize my thoughts, the government goes first. They have to present their case. If they present their case and they have not established the elements of a crime, so let's say they say, a good example of this might be in a DUI trial. Let's say they go through the DUI trial, they present all of the evidence. They say, okay, well, this person was under the influence and they were driving the car and they hit a tree and they did a toxicology report and the blood results came back and whatever the numbers are, and we have all of the evidence. And you say, okay, that's a pretty good case. But let's say, for example, that they just didn't identify the driver. For some reason, the prosecutor, this never happens, but if the prosecutor just missed identification. So they were talking about a DUI, they were talking about somebody who was driving the car, about an accident, about blood results, all that stuff, but they didn't identify the driver. Well, they're missing a key element of the crime. They've got DUI, they got driving under the influence, they got an accident, all that stuff, but they don't know who the driver was. So they haven't proven their case yet. So at the end of the cases, at the government's case in chief, the defense can say, no, we don't have anything to present. We just move for a verdict. They haven't made their case. They haven't presented anything in court. The judge goes, yeah, you're right. You haven't hit the elements. Sorry. So you haven't stated anything. So the defense doesn't have to present anything. So I don't think that's going to happen here. Liberty or Death. It's a good question. I think that there probably will not be any success in a continuance. I think the judge will just stack it on there and they'll just move this thing forward. Maybe a small continuance. Again, I don't know what the rules are in Minnesota. So, let's say, for example, that there is some sort of provision that says all discovery has to take place no later than 10 days before trial starts. And we add this new charge in and they want to disclose a bunch of stuff, but they're within the 10 days. Then the judge really has no choice but to grant a limited continuance to get back in compliance with the rules. And so we're talking about a lot of different moving parts right now. And I think it's too early to tell. But yes, I mean, the judge could find that if the government didn't present their case, issue a directed verdict or whatever they call it in Minnesota. It's just about, whether, are they going to miss an element like that? Probably not. So the likelihood of that ever happening is very small, in my opinion. Liberty says, I haven't heard if Chauvin is a martial arts expert as well. If he is, would seem relevant to have someone like me with 30 years under my belt to testify on chokehold and pain compliance. But if Chauvin is not a martial arts expert, how wouldn't that be prejudicial? I could testify to the custom of martial arts, but if Chauvin is not a martial artist, doesn't seem to be relevant. Yeah, and it's a good question. I think that what they're talking about here was a witness and not Chauvin in particular, but they're talking about what witnesses can testify about. So yesterday we talked about Genevieve Hansen, who is another government witness, who is a firefighter. So she is now going to be able to testify about what she saw and about what she, what her skill set and her training would have commanded that she do, but she can't jump to a conclusion about she could have saved him. So it's a pretty clear line there. And we don't really know what the testimony is going to look like in the course of a trial. Is she going to get close to saying that? This is where defense attorneys, here Eric Nelson is just going to be like this, waiting for this testimony, wait until she says something like that. Objection. We already dealt with that in a motion and eliminate. She's not allowed to do that. And so here they're talking about that same type of thing. She can say all of that stuff about what she observed, but she can't make any conclusory statements about the fact that she believes she could have saved George Floyd. Similar type of conversation happening with this martial arts person. Right? If he's going to come to a conclusion like, well, I would have let off of that chokehold and he would have survived, probably not, because he's not qualified to talk about the possibility of survival. But he might be qualified to talk about how chokeholds work or some of those other elements. And so it's all going to be sort of, the judge is fleshing out sort of the bounds of what the rules are. But when it gets into the specifics, that's where the defense attorneys and the prosecutors are both just on edge, waiting for something that is getting really close to that line that can support an objection. So we'll see where that one goes. Jeremy says, would it be useful to compile data on a police procedure of controlling a person using the same method? How long it's been in use, how often it's used, how many times it resulted in death, etc. Yeah, I think that stuff is very useful. That data is hard. So I've looked at a lot of that data and tried to analyze it and bring it together for the show. The problem with it is it's difficult to find, number one. There are certain studies that exist, but it's hard to sort of correlate data between different departments and summarize it in a way that I think is easily digestible. There are some good studies. I think I posted one over on Locals today responding to another question about the decrease in crime rates. And I think it is useful. I like the data, but I'm not sure that even if we had, let's say, I think the defense could come out and say, we've got data from 100 different police departments. We've got policy manuals that all say that they use this knee on the neck approach. Here are documented reports or policies or manuals or procedure books or whatever that dictate that this should be used. I think that they can present that, or should at least attempt to present it, to show that Derek Chauvin's knee was not outside the norm. It wasn't negligence. It didn't fall below that standard. Therefore, it can't be third degree. It's not eminently dangerous because other departments are using it. And we'll see what the judge does, whether that evidence is going to be admitted or not. I think they'll get that in through the use of expert witnesses. They'll bring in other police officers or other, use of force experts. They'll just have them testify about that stuff. And so rather than coming in and slapping a phone book of reports and Excel spreadsheets and data, you bring in an expert witness, and they're the ones who help explain that to the jury and to the court. Hack Consulting says, does it have to be a unanimous vote by the jury? Yes, it does. How does Chauvin get jury convicted on the charges? What charges are there? Just one, two, many? So there are two for sure right now. We have two. There may be a third for the third degree murder, and we'll see if that what the judge does with that tomorrow morning. Yeah, the jury does need to be unanimous. Otherwise, it's going to be a split verdict. That'll be a mistrial. How does Chauvin get jury convicted on the charges? Well, they just present the evidence. The government presents the evidence. The defense presents their evidence. We have cross-examination by both sides, opening, closing arguments, goes over to the jury, and then they issue a verdict. Dr. Renal MD says, Renal MD from New York says, as someone selected for jury duty, do you have to give so much personal data on your background in life? Can you just say, I'm here to serve, but my family and racial upbringing is my privacy? Yeah, I think you can say that. I don't know what the court will do with that. Sort of depends on the judge. A judge might say, well, this is part of your duty. You got to tell us this stuff. This is something that, you're a citizen. We need a jury of your peers, of his peers here. You got to answer those questions, right? You're in court. This is part of the process. Answer them. Or you might have another judge that just says, okay, I understand that totally. Privacy is important. The judge will probably push you on that. So if you got onto the bench and you started to say, I'm not going to answer those questions, the judge is going to grind you a little bit on that. And we saw that yesterday when we had one of the women who didn't make it onto the panel. She said specifically, I can't be impartial, right? Something close to that effect. So I can try, but I can't guarantee to be impartial. And that was pretty unequivocal. And the judge did not let her get away with that, right? He asked her three or four times, are you sure? Let me put it another way for you, young lady. Let me hypothesize it in this manner. And she said, no, judge, for the 50th time, I told you, I can't be impartial. So the judge is going to dig, make sure that there's no possibility of rehabilitation, make sure they can really get to the root of it. If you prove to be uncooperative, if you prove to be too difficult, and you stay on your, plant your feet in the ground and don't let the judge knock you off base, then maybe the judge will ultimately excuse you. But the judge they don't want to do that, right? They've heard many jurors come into court and make racial comments or say something, hey, my kid's in school or whatever. The judge says, I don't care. I don't care about any of that. Can you be fair and impartial? That's it. You're going to serve. So you could try that approach. I think you'll get different responses from different judges. All right. And our last question, this looks like, comes over from Ryan over at Locals. Says, question for Robert. Given the political environment surrounding the case and the pressure applied to the jurors to declare Chauvin as guilty of all charges, how can we consider this situation where a fair trial could possibly occur? Why isn't there a means for providing protection for the jurors? How is it allowed that a well-funded political groups like BLM can legally influence an outcome of this trial by threat of widespread as well as targeted political violence. So first of all, have they done that? Have they promised a threat of targeted political violence? I don't think that I've seen that. So I'm not sure that that's a fair categorization of it. Now, you can just sort of jump to the conclusion and say, yeah, there's probably going to be political violence, but I haven't seen any sort of explicit threat about that. Now, if that changes, of course, the logical question would be, well, what's the FBI doing about it? What's the U.S. Attorney's Office doing about it? What's the Department of Homeland Security doing about it? And I just don't know that I've seen targeted political violence. It's been implied, but I haven't seen a direct threat of it. It seems to me that we are nearing or have already passed a threshold where our legal system is being compromised by the ongoing threat of what amounts to domestic terrorism. Thoughts? Thanks. So this is a tricky question, right? Now we're talking about people's motivations and some of these sort of implied threats versus direct threats. You've got a lot of people making different claims. You've got a lot of people saying a lot of different things. And so we got to be careful before we start ascribing, one statement to the entire organization. And I've been trying to be consistent about this, right? It's the same principle. Let's take the Capitol Hill riots, for example. What the media did, what I thought was totally inappropriate, is they tried to say that all Trump supporters, anybody who is MAGA, anybody who's a Republican, anybody who wore a hat is an insurrectionist by association, just by implication, just by the fact that they were associated with the Trump brand in any way, shape, or form. That implicates them. I didn't think that was fair because it's not fair. It's not fair to do that. But we got to apply that same standard over here as well. If there's a couple people saying that they're going to torch the buildings down, well, those people need to be dealt with, but I don't think it's fair to sort of tar and feather an entire movement for the select statements of a few individuals. And it does need to be something concrete. We covered a lot of people from the Capitol Hill riots who were not even there on January 6th, who showed up the day after the fact. They were sending evil text messages. They were saying things like, oh, if I find Pelosi, I'm going to do whatever to her. But that was on January 7th. The guy got arrested the day after for getting into a street fight with somebody over a parking space or something like that. Another guy got picked up because he sent some text messages and he was in possession of ammunition. But he wasn't at the Capitol. He wasn't even involved in it. He was there the next day. And so should we be focusing on that, right? We're seeing a lot of people who are being incriminated and picked up for just being loosely associated with some sort of political movement, which I don't think is right. I don't think that is under anything that the Constitution speculated, that we would be using our justice system to overly politicize and attack what I think is legitimate political protest. And so same in this case, if they're making targeted threats against any of the jurors, or if they're implying strongly, yeah, they need to respond appropriately, and they need to make sure that they are secure and they are safe and that there is no undue pressure on anybody in that courtroom. But I haven't seen much of it, to be honest. I've heard a couple jurors express concern, but the other 5 jurors today, when I was listening in on the proceedings, they all were sort of, it's a high stakes game. A lot of high pressure. There's going to be high pressure. This is the crime of the decade, maybe the century. And it is intense. It's going to be intense. People are going to have anxiety about it. And so the judge is going to allow some of that to go on. But the question is, where does that balance shift? Where does it become, okay, this is just regular high anxiety, high pressure. You're doing your civic duty. Thank you for making the sacrifice in the name of justice. Where does it tip and become something that is now problematic and dangerous, and something that is exhibiting undue influence on the final outcome of the case? Right? I'm seeing a lot of people claiming out there that this is not a fair trial. And I haven't seen that yet. From what I've seen in court, this judge is pretty down the middle. I mean, he's doing a dang good job, in my humble opinion, on this case, because he's being even-handed to both sides. I think that certainly there is going to be pressure from the public on both sides. You're going to have jurors who are going to buckle under that pressure. Hopefully not, but somebody probably will. We'll see. It's a good question, and I don't mean to condemn your question at all. I think it's a very good question, and it's a very thoughtful question. I appreciate you asking it. I just don't know that I've seen some of what you have proposed here in terms of what their underlying premise is. But if that changes, I mean, if the head of BLM or somebody from BLM says, unless Chauvin is convicted on all accounts, we're torching Minneapolis, that's a whole different ballgame. Right? That's a real threat, and I think that there's some truth behind that. And so we know that the DOJ and U.S. attorneys and Department of Homeland Security and all of the other law enforcement agencies are going hog wild over what happened on the Capitol building on January 6th. We'll see if they apply that same level of scrutiny in this situation.